Item 1501. No.
The appeals therefore succeed and accordingly allowed. In viewing judgment orders as referred to in paragraph 2, shall stand satisfied in court. At the end, we may record our surprise that the High Court adopted the course it did without reference to the well-established position of law as is demonstrated above. We summarize the findings, the issue direction as follows. The bar under section 362 CRPC is almost absolute. The only exceptions to the bar, which would then permit the invocation of the inherent powers, would be if it is necessary to meet the ends of justice or to remedy the abuse of the process of law. Other than the above two circumstances, such inherent powers do not permit the doing of what stands prohibited by the text of the statute. To clarify, it may be stated that when a court finds itself in such extraordinary circumstances, the reasons for exercising such power should be recorded, justifying the imposition thereof. We direct the registry to circulate a copy of the judgment to all the High Court for necessary dissemination to all concerned. It is our hope that lending clarity coupled with the necessary information being supplied will curb such unjustified use of power. Appeals are allowed.
Much obliged.
One minute.
Well, I said scan indulgence plus may I mention a matter which is listed on 9th Millers. The order came to be released.
Is there some correction?
Yes, plus slight.
What is it?
Your Lordship, may kindly have the first order on 1st of April, Millers, when the matter was listed to the.
No, what is the correction? Tell us.
Yes, Millers. Your Lordship had said plus stay till the next date of hearing. On 9th, when the matter was listed, Millers.
Oh, it is not there.
It is not there. I'm just stay.
Continue.
Information alert. I appear in item 43 alert. The other side is also here. But I am only requesting for a short accommodation.
We will wait for your matter. We will accommodate everyone.
Right.
21.
We will accommodate everyone. No difficulty.
Please, my lord.
Wait for your matter. One by one. Sorry.
If I would just recollect, my lords, my item would be taken as item 1 without listing. My lords would recollect the MACT matter.
No. 1 minute now, not in this combination because the matter was heard by another combination. It has to be. You'll have to wait now, ma'am.
Well, my lord.
1 minute, just wait a minute, ma'am. We were allowing your appeal, but you wanted also on another point, contributory.
Composite negligence.
Composite, sir.
Composite negligence.
Unless both of you agree on that, there's no difficulty. Otherwise, the very same combination has to be. 1 minute, ma'am. It cannot. What are you? You have been practicing this court.
No, I just wanted.
As and when that combination would be there, we will do that. Thank you.
My lords, if I would just if I could just pass the written notes, my lord, so that it would go. I would at least do it in the e-filing.
You may do one thing. You may please give it. Why don't you do one thing? Go through it. If in law he is right, then we need not.
I will examine.
No, I will not trouble my lord.
I will do.
Please, sir.
So you do one thing. Go through it, and on Monday you let us know because on Monday again we are not selling the same combination. Please.
Grateful, my lord.
Thank you. So Monday morning you just
Monday morning.
you come both of you.
Speak.
Item 1.
Wait, please.
Yes, please.
Was convicted under 326, acquitted under 307 on an appeal against.
So today, what is the matter listed for?
Your Lordships are of the view, my lords, last time in a different combination. I said 7 years is enough, my lords. I concede to that. It fell from your Lordships also. They have to.
My case is not instead of 10 years, it should be life imprisonment.
No. But you are not here for us.
You are not in announcement.
I have not come, Lord, I need not be doing.
Then that argument is a futile.
When he came to Supreme Court, your losses were inclined to dismiss the appeal. It's the statutory appeal, Lord. Then he came with a proposal that let us settle it. These kind of things are there, Lord. Your losses have to hear the appeal itself.
Otherwise, my lords, I have a short point. I was not heard on sentence by the High Court when my reversal was, when my acquittal was reversed under 235. So anyway, sentencing part will not necessarily follow your Lordship's judgment. It will have to go back to the High Court then.
So far, sentencing is concerned, my Lord.
We may do one thing. Think over. We are very clear. Either we remand or 7 years is what we are proposing. If you still want to argue, then you, not today, then we hear you, of course.
That it has to go back to the High Court. Then.
Yes.
High Court could
Yeah.
have announced the sentence without hearing the accused. It's a settled principle of law.
Anyhow, we'll have it on Monday. Think over it.
Milord, no issue, Milord. Have it on Monday, Milord.
Tuesday.
Tuesday is better, Milord.
Tuesday. Okay.
Better, Milord.
Tuesday.
Yes, obliged.
But we are very clear now.
Yes. Milord, I fairly understand, Milord, because I was checking it, Milord, that he was required to be heard.
Yes, you have to be heard.
Next case.
Instead of it
I
more
don't-
time, Milord, we will ask for the life imprisonment instead of this.
What is the stage of trial?
It is, Your Lordship.
But,
The charges are yet to be framed, Your Lordship, and for the petitioner in this matter.
Right,
And an
about the
application
photo.
of discharge has been filed by one of the co-accused and they're lingering on that. Now the final date for being heard is on 20th of May of that discharge application of that accused. And for the complainant, Your Lordship, my Lordship.
I hear for the response.
As per the last order, there was some compliance to be done by the state. We were supposed to file the order where the accused has been convicted in a
Correct.
3070. We have filed an additional affidavit where in page number 51 and 53 of the order, it has been mentioned about the role of the accused and the convictions.
Page number 56 of the application filed yesterday.
Yes.
Compliance affidavit.
Compliance service. Yes, what do you say in compliance affidavit? Yes.
Can I make request that as per the last order, the state was supposed to do the compliance within a period of 4 weeks. And thereafter, my lords were kind enough to grant us time to respond the same within 2 weeks thereafter. However, the state has done the compliance only day before yesterday. So in the late evening, we received the entire compilation.
So what do you want?
Lord, we could not respond, my lord. Can I seek some time, my lord, to respond the same? Because if it would have been done it earlier, my lord, we would have been able to respond to the same.
Okay.
My Lord, twice the state has told that how this mischievous man is doing in that area. In fact,
It's okay.
307
This
My
court
lords
has
have
given the opportunity
extensively
to counter the state's version. The time has to go.
Rejoinder, how much
My
time?
lords have also directed us to give us a
I
seal
know.
cover the report.
Just keep it with yourself. Rejoinder within how much time?
My lord, 2 weeks,
2 weeks छुट्टी के बाद दे दीजिए.
please, highly obliged.
No, interim
Grateful to my
order.
lord.
Obliged.
Yes.
Item 3.
I am for the petitioner.
No, it is for now. In the
Cancellation.
counter, they say that 2 witnesses have already been examined out of 7. Only 5 will be done.
I am for the
ये कल को करना है.
Petitioner के पास.
Yes, also the petitioner.
my lord, I am for the petitioner, my lord. My lord, the
You
state
are
has filed,
challenging the bail, na?
my lord.
Yes, sir. Out of charges have been framed. 2 witnesses already examined. 7 out of 7. And why should we interfere now?
My lord, the state has only filed its reply yesterday.
Thank you.
only.
We are not ready.
You have to make out a case.
Next.
Item 4.
Number 3.1 to the.
Pass over in this.
Sorry?
We are being led by learned AMC, Mr. S.V. Rajan. He's on his legs in a different mode. I'm seeking a pass over in the matter.
Okay, but ask him to be here when the second part, immediately after the fresh matter has been taken up.
Item 5.
The state and private respondent have filed counter affidavit.
The joint investigation will confirm.
No, but there are 2 or 3 things that were not pointed out on day 1. Your lordship said file the counter and come. There are 4 other FIRs against him. He's a developer who's collecting money with everybody.
1 minute. Have you granted interim bail?
Your lordship had granted ad interim
At
protection.
interim protection. Right?
Yes.
Now, in your in the counter, they say he joint investigation.
Yes, well, that's the first sentence.
Ah.
The state files a short counter. I was impleaded on the last occasion. I am for the complainant. Plus, in this matter in 2017, he signs a resettle. I file a police complaint. He signs a settlement with me that he will give me the property.
These are not recovered.
Plus, we just have one.
We have seen your counter.
As to the investigation, what we found out during the course of the investigation, there are 3 more FIR.
In your FIR, in your counter, where do you say that?
We filed a counter, but not.
You will be seen a counter.
One of the counter is not on record.
Thank
You
you.
will find it in the morning. Now, as to the investigation, I just put it before the limited order. It's not limited to only the check bouncing case, there is scam of 1 crore rupees. And the documents
So
need to
there
be
are more than
verified.
20 victims.
My lord, this is nothing to do with the present case.
Please, thank you.
Your lordships are adjourning it.
No, we are dismissing, we are allowing the application. Thank you.
Because your lordships have told me on the last occasion that you will permit me to show one thing. The
Thank you.
magistrate has found false bail bonds. This is a man who's giving false documents also to the magistrate. He is not entitled to this kind of protection, and this is not brought out by the
What
state.
false bail bond?
Because in 2019, in another case, he files fake bail bonds. The magistrate registers.
Why is he confident in that case?
Thank you. Next case.
If you oblige, my lord.
Please, lordships.
Yes,
Lord, after notice, she has joined investigation.
Lords, I am appealing
He also states that he found
as far as the role of present petitioner is concerned, my lord, she along with the other two accused, my lords, defrauded the 18 investors, 16 investors, my lords.
But you have not filed a counter.
Lords, I filed a counter, my lord, it is
There's a counter.
Counter is filed, sir.
Counter is there. I have filed a return also.
counter and return both are filed. my lords.
Fiscal cover.
May I just say?
You have received 18 lakh rupees in your account.
Please,
In case of investor fraud, you don't have the license, you are luring people.
It's only for a minute. I have filed a return. Today also it's only one thing.
Next
It's
case.
only for a minute, Manoj. It's a lady with whom we are
We
concerned.
have seen that.
But there's one suggestion, Manoj. May I just put up that suggestion to your
Oh,
office?
yes.
Only one small suggestion. I filed a return. But the allegation is with regards to 18 lakhs.
So I will repay. That doesn't
No, I am
purge you of the offensive.
I'm not repaying, Manoj.
That, no.
The family
You
owns.
will deposit it back into the firm's account. That offer is virtually admission of guilt.
But I'm suggesting
Not a
something.
case for anticipated.
I'm
payment.
suggesting something.
What else?
Yes.
Because the family owns a property which is
No, what do you want to say? Yes.
approximately 5.5 crores. That entire property may be seized, Manoj.
Thank you.
I put it,
Investigation note.
take appropriate proceedings.
Lady who has to consent.
Not-
into the
Not in the scope of an anticipatory bail proceeding, sir. Thank you.
Then in that case, Manoj, may I seek one indulgence, Manoj? Could you also grant me some liberty, Manoj, to apply for regular
We
bail?
are not-
If we decided.
You surrender? You surrender?
Manoj, if Lordship grant me protection, Manoj, she is the lady, Manoj.
No.
The police has a right to make custodial investigation in this case.
Minor, sweet. Public.
Because brutal murder of 13-year-old boy, there are multiple stab injuries. The case is part heard, 12 witnesses are already examined.
Correct.
And there are just 55 witnesses.
Sorry.
Lord, may I say one thing? Well, in this case, only one thing.
You know, in this court, you don't even have to open your mouth.
No, Lord, but kindly see, Lord,
No.
the first
If the case is made out, you don't have to.
Lord, first see the first order issued by your Lordship of first order.
Yes,
But
yes.
in that, my role, one eyewitness says,
Thank you. Next case.
Lord, kindly see.
Thank you. Next case.
Lord, kindly see. One
Next
witness-
case.
Item 8, may it please your lordship.
Okay.
My lord, in this matter, now at this stage, the matter has become interrupted. My lord, the lower court has rejected the bail.
Seeks permission to withdraw the present petition.
My lord,
Present that on account of intervening developments, the present petition has become
My
invalid.
lord, one indulgence, Lord, the liberty may be given to me. I'm withdrawing it. Liberty may be given to me to revise my petition. As a suppose his bail application is restored here, Lord, I can.
Nothing.
That remedy you have available in the court, you can avail.
Yes,
Lord,
please.
may I give up the.
Thank you, ma'am. Thank you.
Minutes on the last, minutes have been granted anticipatory bail on 24th of March. Mediation has failed minutes. On the last date minutes, remember, Mr. Wasim Qadri was appearing from the other side. Minutes have spoken to him.
The conduct of the petitioner.
Minutes have minutes, may I say, no, completely wrong minutes. May I say, I went, please, madam. I went to meet Mr. Qadri along with the petitioner in his chambers. Minutes, to my understanding, he said, I will not appear, but I have explained the issue. My lord has directed me, sort this out. No message has been sent by my client.
Gentlemen, 1 minute.
I've taken him, I've spoken to him and tried 2 minutes. If I said, if you are hurted, we have not done
Thank
it.
you very much.
I do.
Item 10.
Dismiss.
I'm sorry, Minutes, I'm sorry.
I thought we were very clear.
No, Minutes. My lords have granted me anticipatory bail.
Yes, so that is an interim bail. That's not a final order.
No, Minutes, that was an order. Minutes, please see the 24th March order. Minutes. That was
Interim order only.
May I say, Minutes, only one thing.
We are very clear, gentlemen.
Minutes, those messages are not my messages.
Very clear, sir.
No, Minutes, not my messages, Minutes. Minutes, may I say this? If they implant these, that number is not mine.
Gentlemen, just
Minutes.
we were very clear. We made it very clear that you have to sit with Mr. Kadri. And if Mr. Kadri felt hurt, we have to protect him. That's the end of the conversation.
Minutes, I went there. He said, I have no problem. But I don't want to get this.
That apart, we are not inclined.
Minutes,
That apart, we are not inclined.
Minutes, may I say one?
Call the next case, please.
Item 10.
10 I am seeking passovers.
Passovers will come immediately.
Well, in item 11, the state too is opposing grant of bail. They are also seeking cancellation. The lordship wanted to know from the state. They have filed their counters. But this is a case, actually,
The interim bail which has been granted.
Yes.
I decided finally.
No. Well, the issue is something like this.
Yes.
The lordship may look at the reasoning. The problem we have today is, my lords, look at the reasoning, my lords, at page 2. My lords, in a 309 case, my lords, what the High Court presumes is, it presumes even before the charge sheet is filed, investigation is complete.
Not an interim order.
Well, it's an interim order, no doubt, my lord, but then the basis on which your lordship was inclined, well,
thank you.
my lord, your lordship kindly consider this, my lord. In fact, my lord,
Thank you.
your lordship wanted to know what the state's position is. Well, this should not, my lord, I have one point, my lord, your lordship kindly bear with me. The High Court says that it is a case of rash and negligent driving. Well, if it has come to a point.
FIR is registered for a rash and negligence.
No, FIR is not, I mean, that's it. Right?
High Court for observation.
FIR is not for.
1 minute,
Right.
Please. If the High Court finally says that it is a case of
If
you
this
come
is
back,
a case of.
you come back.
My lord, it's a prime.
If the High Court finally says this, you come back.
No, it's not like that, my lord.
Not at this stage. Not inclined to infer at this stage.
Well, the lordship may kindly say that.
Thank you.
This observation should not come in the way, my lord. I have a problem, serious problem. It's a, my lord, they have broken through the security cordon. The police themselves have eyewitnesses.
Next case.
It's a case, but at least the observation will not come in the way, my lord, because
the High Court shall pass final order on influence of the observations made in the interim order.
Very good.
Very good. Grateful.
Item 12.
Well, the respondent state has not entered appearance, mother.
State has not entered appearance.
But I'm seeking 2 weeks' time.
2 weeks, take 4 weeks now. 4 weeks,
4 weeks.
file response, failing which no further opportunity. Rejoinder 2 weeks. List on for date.
Interim order to continue.
Interim to continue to the next date.
Item
Bail has not granted on. Item number 12, can I pray that the lordship may districts in the second week of July?
We have said 4+2, some date will be there.
Very great. Manoj, bail has been granted on parity. Now the OIQs, Manoj, your lordship.
That has been paused.
Yes.
Correct. Yes.
Yes.
We'll have to issue notice.
Yes.
Notice.
2 matters.
Notice दोनों में.
Good.
Yeah, this will be an item number 13 and
63.
Notice return number put it this.
Item 14.
Tag it. 14. Yes, please. How many bail applications you will file? You tell us this. One after the other.
Please see page D.
In a 498 304 case, how many bail applications?
Please see page D.
Yeah,
Just see page D. Not a single witness has turned up for the last almost 1 year.
Sorry.
Can you see?
How many bail applications? There's a limit to you will abuse the process of law.
Observe the trial.
Thank you. Thank you. Next case, please.
Item 15.
I'll withdraw them.
It's your prerogative.
I'll withdraw at this stage.
Permission to withdraw. Okay. Please, sir.
Item 50.
Please, sir.
Yes.
Lordship, in this case, is it a comprehensive policy or?
No, it's an act only policy with personal accident insurance.
Third party.
Third party. They have ended to be third party, but he is the brother in.
It's a third brother, he was just given the vehicle.
Neither I'm the.
He was given the vehicle just to proceed to the that airport or where. So why is not covered in the definition of a third party, please?
Because in a passenger car,
He was not a gratuitous passenger, Mr. Counsel. He was not traveling in a vehicle which was being used
the case of
as a taxi.
the case of,
He was a relative of the deceased.
in the case of Rajni Devi, that has been clarified. The case of Balkishan, that has been clarified. The fact
That has all been considered by the High Court. That has all been considered.
That has not been considered.
We are attending facts, leaving the question of law open.
Item 60.
On
Please, Your Lordship. Lordship, in this case, Your Lordship, I must, at the outset, Your Lordship, there is a the third round.
It's an execution. Then
Lordship, what has happened that, my Lord,
what has happened?
Lordship, executing court says that it is inexecutable. Revision court says that you go back to the executing court. Now, my Lord, that. Lordship, in my, for a moment, Your Lordship, may.
Thank you. Next case.
17.
Grateful.
Last round, the questions are possible for items
17 is.
Item 18.
But this is one serious.
From 1986 till 2025, you are occupying. You tell us this.
Yes.
How much time you want to vacate?
No,
Straight away, we are telling you how much time do you need.
No, Lord, that's
Thank you. Thank you.
No,
That's the only option.
No, Lord, permit me to state the point. There is a very serious procedural lapse. The writ petition was dismissed in 2012. After 10 years, in 22, an application is filed for restoration. That is also dismissed twice. Third time, there was only a notice on restoration, and the writ petition is decided on merit.
On that side, when we were there, we used to.
But for 10 years, bona fide need.
1 minute.
Somebody has a bona fide need for 10 years.
Will you just listen to us? That's the end of the
road
now. But while we were on that side, we used to call you Hukum. Thank you, Hukum. You want time, we'll give you time. No problem. There, we'll give you time.
Lord, this is like a commercial.
Whatever time, no different. On time, there's no difference.
Lord, shop.
Some reasonable time.
6 months.
Yes.
As Malas has pointed out, 6 months.
No. Be reasonable.
Malas spent 33 years to matter was in the High Court.
Gentlemen.
So then leaving 3 months would not matter.
9 months. 9
months.
9 months, okay. Usual undertaking. That's it. Thank you.
Item 19.
Yeah, please, madam. Your judgment है sir. Thank you. Judgment है. In this court, you always have the date.
Highly obliged.
Next.
After the petitioner, suppresses the earlier petition, files another petition in 22. Notice is not even issued to me, not even served is a different issue. After the matter is heard, I am served on 30th as of Orient Insurance Company. But this is all right. Matter has been decided expired without even hearing me by the High Court. And madam, he's been exploiting the software side. It's a fresh matter, madam.
Fresh matter. In fact, it has to be remanded. Anyhow, notice is done.
But let me have a stay of the. Great.
31. I'm seeking 4 weeks time for filing some.
Sorry, ma'am. Sorry. Ibrahim was the third son of Imam, and he had right. He died
My lords, can you
issueless.
permit me
So
to-
therefore, there's nothing wrong. Plaintiffs have a
My
right
lords,
to
can
that.
kindly permit me to bring relevant documents on record since 1967.
Thank you, ma'am.
My lords,
Thank you.
my lords,
We are telling you, just one. Imam Shah had 3 sons.
Yes.
One of them died issueless. He had not married in fact. The property has to devolve upon the remaining.
They were
Thank you.
He passed over the matter. I'm seeking the pass over.
Pass out, no problem. But pass out will come immediately, we are telling you.
Okay.
Item 22.
And Sitting Millard, this is a fake insurance policy should be someone.
Why I agree with you, you execute the order against the owner, it's a fake policy.
For one time, vehicle owner has on date not appear for the.
That's your problem, insurance company can't be held responsible.
Insurance company not taken any action against.
That's immaterial. We
only one thing.
Let us tell you, page 8 onward, we have to struggle to find out what your grounds are. Thank you very much. In future, who's that advocate who has drafted this petition? Tell him.
Item 23.
Please, my lords.
Similar
118 posts.
Similar dismiss, no?
No. My lords, 2 of them for a different district.
How many years after
My lords, notwithstanding that,
16 years gap in filing.
notwithstanding that, this.
The High Court has already fixed the cutoff date, and you then wake up, try to join the bandwagon.
My lord, the point is.
We have already dismissed similar cases.
That is with regard to other districts. In this particular district.
That's all right.
No. Each one is allowed. Here it is allowed. The third petition is allowed at page 74, 73, 74.
74.
We have to put a quietus, Mr. Hegde.
My lords,
They for the first time agitated this after how many years? Please tell us.
my lord,
The first time these petitions
No,
agitated the cause.
the people were agitating.
Forget about other people.
No.
Forget about other people. The
We
High
have
Court has
already-
ratified market distinction.
We have
There was a stay by this one.
Thank you.
Yes, after the stay was not vacated, then these petitions came up for hearing.
All.
Lord, may I withdraw then?
You may withdraw.
Item 24.
Lords, 24, Lords, I beg to appeal for the petition. Lords, there's a huge fraud is what I want to just.
Fraud of what?
Lords, you Lordship, just see 3-4 facts, Lords. The FIR is on 24th November 2011 and
What is the question of law? You tell us this.
Lords, the question of law is this, Lords, that your Lordships are examining. Lords, just 2 minutes, Lords. Lords, just 2 minutes, Lords. That's all I'm asking.
Thank you.
Lords, please just 2 minutes, Lords.
Thank you.
Just 2 pages, Lords, your Lordship will see.
We have seen.
How the
We have
rules
seen
for
what
the
is there.
Lords, how the rules over the court size have been.
We have seen what is there. Thank you.
Permit me to just please, okay, 30 seconds, Lord.
Thank
30
you.
seconds, not even 2 minutes.
Yes, please.
Please consider that. Lord, that's so grateful. Lord, Lordship will just see 2-3 pages, Lord.
Yes.
Well, the statement of the car owner is that the driver is one Mohanlal. This Mohanlal, instead of becoming the accused, my lords, he becomes a witness.
Yes.
He says, I'm a farmer now. And then he says, I walked up to the car, I saw it, the car speeds
Come to
away.
para 11.
Yes, my lords. The include order, your lordship. Yes, absolutely.
The whole case of the insurance company involved on this Karan Singh Kharab, owner of the vehicle, but it is noticeable.
Yes, my lord.
There is neither summoned as a witness nor his statement.
Thank you. You had your 30 seconds. Thank you.
My lords,
Thank
after
you,
this
Mr.
Mohanlal,
Counsel.
he can go into criminal trial, my lords.
Thank you.
Some other guy gets prosecuted as the driver, my lords.
All right. Thank you.
So,
Item 25.
The High Court found that after putting the appeal, found that. What I'm requesting.
I should have transferred immediate
notice. Please notice. That is this. May I suggest your.
We are giving issue notice.
I'll just say. The High Court found that it had no jurisdiction.
What do you want?
Today, Lord, your Lordship may say that the entire will be transferred to High Court bench, Lord.
Without notice.
One particular date, no prejudice is going to be caused to medium.
The other side was on notice. The other in the High Court. It was their objection.
It was their objection.
So then they have to be heard. Without notice, it can't be done.
Item 26.
Administrative side है तो वही करते हैं वही राजस्थान में मुझे होता है सर जयपुर jurisdiction की जो
Sorry, passover will come immediately.
Yes,
Yes,
Item 27.
whether this interim order is attained finally, just check up in the meanwhile. Huh?
It has.
It has. And nothing will survive. Anyhow, let's see.
Item 27.
wait, please.
Lordships, we pass it over, your Lordships, on the last occasion it desired that the person be present. I'm just.
Yes, who's that counsel?
Lordships, we're just securing if anything is around. Lordships have taken a stern view. It's my request that.
If this petitioner is trying to mislead the court, really, take the court as granted. Yes.
Call him immediately.
Item 55.
Please go to 55. Item 55, the petitioner is a serving police inspector.
Just one.
Yes.
Please.
9 लाख रुपए का सामान खरीद कर
Yes, petitioner is a serving police inspector who's been arraigned in a false case because I have filed a complaint for misappropriation against my superior.
NBW had to be issued against.
My lords, in this case, the section 70 notice has been stayed by a coordinate bench.
We have seen that.
The reason being, my lords, I'm not absconding. I'm still reporting to service.
Yeah, correct.
They have said that this notice is in aid of investigation.
Thank you.
My lords, please, in the current case, because I have an unblemished service. I have been
Thank you.
Item 56, I'm seeking a short accommodation, my lords, today.
Accommodation for?
There was some mistake from my part, my lords. I was.
What do you want?
Next.
Adjournment. Chutti ke baat dijiye.
Speak, my lords.
Sorry.
It's an anticipatory.
Next.
Item 57.
He's a 35-year-old petitioner. That's 1.5 years into custody, 86 weeks.
Fiction story bana diya hai.
Stage evidence.
Notice.
You return to service through standing counsel.
That of course.
Item 58.
Notice. 58, who's there? 58. No one is there. Any of you are issuing notice, whosoever is there.
Item 59.
That's against the same, sir. Against the same order, Lordships have issued.
58 में just एक wait a minute.
Sorry,
नहीं होगा सर. डायरेक्ट बिना सरेंडर का हाईकोर्ट का 4 महीने की बिल ग्रांट की. इसे डायरेक्ट पुश आउट किया इसके साथ. सरेंडर कर रहा है हाईकोर्ट के सामने क्या एक्सटेंशन के लिए.
We'll wait for 58 first. Yes, Mr.
So the 59 Lordships have, against the same common orders, Lordships have issued notice and stayed further proceedings for 2 of the accused.
But now you're accused number 4.
4 and 5. For advocate and HR executive.
Okay.
Lordship may just have this order.
Same order.
Same. Lordship can be tagged with that.
Tagged.
Grateful.
Item 60.
That's evidence closed or the notice किया. Service report. What is the service report?
Service report.
Yes, sir. Someone has filed power. Yes. Yes. Item number 60.
The order was uploaded only last afternoon, my lords.
What order?
The impute order.
Alright, it's a matter wherein the defense evidence has been closed. We given one opportunity. What is there?
हमारा लास्ट ऑर्डर पर लास्ट ऑर्डर Sorry, 60.
So the petitioner is not.
It's not there. Not there. We'll close it now. We'll pass it over. Yes, please.
Do you have any objection? One opportunity being given.
What is wrong? It's not the first opportunity, my lord. This is a
Doesn't matter. We
the third
give one opportunity. It's just an opportunity to lead defense evidence. Why should we close that?
If he's so bona fide, he should have filed the section 91 that he's filed just after the report of the past.
Let the other side.
My lords.
Yes, please.
What's on the last occasion?
Mr. Anandi, we presume that you will be proceeding in the matter.
Lordship, please.
Now you tell us one thing. Why should you not pay 50%? Today we may not finally hear you, but 50% of the areas you please release in the favor of the employees. This is what we had expressed last time also.
Yes.
So 50% you release.
Well, may I?
We have checked up. There is no stay of the impugned order.
Your Lordship, sir.
Only contempt.
The same process. So, my lords,
We will only say
earlier, my lord,
what we propose to do.
yes.
Rather, you should volunteer. Generate goodwill in your state for your employees. Pay 50%, subject to the outcome of the petition, and how to protect, assuming that you succeed, is something which you will have to tell us, or we can ask.
They are in-service employees.
Yes, correct.
If at all you win, then the consequential directions can be given.
Yes, yes.
No equities will be.
All stages we have worked.
One
I
minute,
take
sir.
it the question was put to me, not to my learner. I have prepared a short note, which I may hand over, which I would like to place for your Lordship's consideration before your Lordship passes any order with regard to 50%. Because I have two contentions.
Yes, Mr. Singhvi.
But Malad, I heard your lordships. Malad, I just heard your lordships. Can I make one suggestion? The amount,
Yes.
Malad, when you draw a Malad's very big line, and then one says 50%, it sounds reasonable. But your lordship will appreciate that the amount for the state is gigantic, it's humongous. It is some 40,000. I'll give you the exact figure, Malad. I'll just take a minute to give that. It's a very large amount. 50% of that will be backbreaking. Your lordship's three judgments hold the field. One, DA is not a vested right. Two, it is not a fundamental right.
Mr.
Malad,
Singhvi,
it will break the back. It will break the back of the state.
One minute, Mr. Singhvi. We have gone through your note. We have also gone through the judgments. There is someone else who joined. Unko mute kariye. Mr. Singhvi.
Yes,
we have gone through your submissions. We have also gone through the decisions you have referred to. There's a lot of Mr. Singhvi joined somewhere else. Mr. Singhvi joined somewhere else.
Yes, he joined in two courts simultaneously.
Doesn't matter, Mr. Singhvi. Don't worry.
Omnipresent.
So he can't hear.
Unmute करिएगा. Mr. Singhvi को unmute करिए.
Malad, I was putting my ear to the screen. That's all. I was not going anywhere.
No, that's all right. But what we see, we have gone through the judgments passed by the CAT, the judgment of the first round of the judgment, the second round of the judgment of the High Court, the order of the CAT, and the order.
Malad,
One minute, Mr. Singhvi, and the opinions of two honorable judges of the High Court. Now, what we propose to do is that two things that we'll request you to come out with a figure 50%, whatever you pay, subject to the outcome, or we pass an order.
Malad, I understand. Your lordship may note 41,000 is the amount. I cannot give any answer to your lordships on that kind of amount for 50, will leave aside 10%, Malad. Your lordship appreciate that. For a state, I can't speak like that. Number one. Number two.
These are your employees.
No, Malad, Malad, I can try and work out some solution, but I cannot promise anything to my lawyer. It will be wrong for me.
What would be the consequence?
Number two, Malad, number two, in the event, then your lordship, Malad, may give us an afternoon in the miscellaneous week. We'd rather argue it because Malad, it's a very huge financial backbreaking liability. In the miscellaneous week, we'll do some Thursday or something.
We have gone through your notes, we have gone through the judgment.
Well, it will require some elaboration.
We are not inclined to even interfere. Let us be very clear.
I appreciate what my lord is saying, but this is not a matter of that kind.
It is not a constitutional right, it is not a fundamental right, but nonetheless, because of your ROPA, they are,
Manoj, the only, Manoj, the reason, kindly appreciate, the single reason, Manoj, the single reason why this amount has become.
Exactly.
Mr. Singhvi.
Before ending.
Mr. Singhvi, we are.
Yes, Manoj.
We are very clear. Okay, we are passing an order. We will come 50%.
Manoj, your lordship may allow us to revert on Monday at least. Manoj, this will be not, we haven't been. No, Manoj, we have not been, heard, Manoj, then your lordship may consider this a very large amount. 50% is impossible, 20,000 crores.
We are scaling it down to 1/4 of Singhvi now for the present.
Put it on Monday, Manoj, then let us seek some instructions.
Not be possible.
Can it possibly be increased?
And thank you very much. What are you saying?
Only one suggestion.
Matter is
No suggestion. Please go.
Contempt court will work out.
Mr. Just 1 minute.
All right.
But there's just one aspect.
We have heard him. Having heard.
Just
The amount will be secure.
but there's just one aspect.
These are employees in service.
Your lordship,
To do it all, you can.
your
You
lordship,
can always.
Board are cancelled.
your lordship,
And in this court,
I beg your
are you appearing for the first
I
time?
beg your
Speak when you are spoken to, please.
I'm so sorry.
We request.
just one aspect that I wish to raise.
You are doing the same mistake which is.
No, Lord, I want to clarify one fact.
Mr.
Retired employees.
We'll simply adjourn it.
No,
That's it.
Kindly pass the order, will just close their lordship.
Yes, Mr.
But my respectful submission is only this, Manoj, that we have no difficulty in paying as per ROP. There's no difficulty there. There are two rubs in the impugned. The first is revise them twice a year.
Correct.
So we are submitting, Manoj. So that is drawn, Manoj, from central government employees,
Correct.
which is not applicable to us.
Correct.
That's point number one. The point number two is revise it in the manner suggested by the tribunal. And there are certain findings which are returned by the tribunal, which say you will do it in this manner, which is virtually acting to central government employees. So those are the two rubs. The third rub, that under Rule 12, areas are not paid. So we are submitting that no areas should be marked on this, because the areas that they are calculated is on the basis that you have not equalized as per central government and you have not revised twice.
What we'll do, Mr.
Yes. So may I suggest now just one thing, just on equities. What we are paying them today, as per our interpretation of the ROPA rules, is 125% more from the time that the ROPA was applied in 2008. So yesterday, my lords, the submission was made before your lordship that we are not paying DA at all. That's not factually correct. We are paying to the extent of 125% over and above the scale in 2000.
What we proposed.
Yes.
Yet there's another thing also,
Yes.
whether they would be entitled to the same amount as is being paid to those who are posted outside the state. That's the third thing.
No, the third aspect is now rendered academic, because that part, Mullahs, has been struck down by the tribunal.
Okay.
And that part, Mullahs, we have discounted. So that third aspect of being at par is something separate. So may I suggest
you 1/4 of the amount which is due, you disperse without any equity. And we'll fix the matter. We'll fix the matter in July. We'll post it in July for hearing. Having heard the counsel for the parties.
But there's only one difficulty. Yes. I don't want to tomorrow be accused of not complying with your lordship's order, because the impugned order says we'll have to work out the modalities. That's what the impugned order also says, saying evolve norms for the purposes of payment in this manner. What your lordship may do is, it shouldn't go as my statement, because
we'll not put it.
If I make a statement, but what I suggest that your lordship say 25%, but give us a little bit of time to evolve those norms, because that will require a lot of working out in terms of nitty-gritties. It shouldn't be twice a year, because twice a year is
we are not entering into that aspect. It's a lump sum amount which is coming out as per the order of the High Court, strictly in terms of
there's no amount which has come.
Sorry, which will follow in compliance.
Just We have heard Mr. Singhvi, sir.
One sentence before Lordship dictates for us, one sentence.
Yeah.
The highest slab of Mr. Patwalia's client's demand is based on twice a year. That's the main issue.
Correct.
Now, Malas, if Mr. Huzefa has got some instructions, then Malas 25% may be workable, but Malas, your Lordship is hearing it. It may, Malas, it may be a back-breaking thing for the state. Financially, Malas, a DA will break the back of the state. We are not running away anywhere. My Lordship's final decree will be obeyed. So give a Malas reasonable percentage. Kindly give a reasonable percentage.
Can I make one suggestion? Let us take instructions over the weekend, just have it on.
Let me on Monday.
No, we'll come up with figures. We'll come up with figures.
Sorry.
So that there is no.
We made it clear, Mr. Singhvi, to you last week, and therefore we kept it. Having heard the concept of the
Kindly be reasonable on the percentage.
So 25%, we agree with, we are saying.
This is irrecoverable also, as your Lordship knows.
Certainly,
irrecoverable.
Obviously.
Otherwise,
We have the
I'm
consulting
ready to go on with the final year in today's state. Set out for final year.
Would release at least 25% of RM due and payable to the employees in terms of the impugned judgment or dated so and so, past by so and so, in case number so and so. So, needless to add, dispersal of such amount shall be without prejudice to the respective rights and contentions of the parties and subject to the outcome of the petition. List the petition. The respondents are permitted to place on record their written submissions within a period of 4 weeks, or let's say parties. Because we have gone through, Mr. Emily, perhaps you will have to file revised. Perhaps. Just parties are permitted to place on record their revised submissions. List the matter for hearing on that.
If release within some 4 weeks, 8 weeks, 6 weeks. No, but the norms will have to be worked. So you're not fix a time in terms of the High Court judgment.
We have said in terms of the High Court judgment.
Great.
So great. Implement we are not allowing. Implement we are not allowing.
It doesn't matter at all.
Implement we are not doing.
Decided that. So they will be heard, perhaps, but the implement has already not been allowed. They may be heard because at the final.
Implement simply tag along.
That's right. In fact, on the earlier question, I understand my doctor said we'll all be heard at the final.
Okay.
Item 62.
But gentlemen, one thing is there. We are telling you on this side. See, if Mr. Himati's contention that they are paying as per ROPA, then perhaps you will have an uphill task.
No.
We are telling you.
But it's
One minute, just listen to us. Mr. Himati has to answer that in the first instance, why did he allow disbursement twice in a year? But, and he course corrected midway and then gave only once in a year. That is something which you have to answer.
yes, it's very well.
There are all KICP norms.
We are just letting.
We'll address that.
That's fine. I'm obliged for your Lordship's observation because it is only in 1 year that we paid twice.
Yeah,
Otherwise, consistently we've been doing it.
But these are your employees. They must give you.
Ultimately, it depends on what the size of the purse.
Well, Mr. Emily.
Yeah.
Let us tell you candidly, we would have dismissed this petition. Why we did not dismiss it is because we will have all India ramifications.
That's correct.
That's the only reason why we.
There are a couple of points, Manoj. One is DA has been elevated at the level of a fundamental right. That's the basis on which the High Court.
His name next week.
Manoj, I can't respond to this. I speak one line.
Yeah.
There are 5 sentences coming.
Wait for a final hearing.
Would your Lordship fix a date?
After date will be there. In July, August meeting. First week, August.
Yes, stop it.
Probably.
Madam's today order will go long. You're very
good.
I'm great.
Thank you.
Item 62.
My Lordship, we kindly have the last order, 17th April. My Lords, in paragraph 5.
What did we say?
My Lords have directed that
Medical exam.
I may go to GK hospital by the state. Now, my Lords.
No. Why did you mention to have it listed?
My Lords, because in paragraph 1, my Lords, my interim bail was ending today.
Oh, good. No, we had said 90 days. Now is that case?
My lord, the prayer was for 90 days. Your lordship said you will give. I'll be very candid. Your lordship said you will give, but not 90 days.
We'll give you some time.
That period has ended. That period has ended.
Yes.
In fact, he was taken up for medical examination. The doctor has advised for 15 days rest.
That's all.
1 month he has already taken rest.
So we'll extend it by 15
My
months.
lords, that was the Gujarat that doctor.
When was that opinion given?
Said 3 weeks. I'm only advised for 3 weeks, not 15.
14 May.
My doctor, my lords.
So the observations are that he will have sleep sufficiently and he needs 15 more days of rest and that will suffice.
I'm only requesting for 3 weeks. So my doctor said 3 weeks. I don't want to ask.
On Dash, we had chart का order reproduce करना चाहिए. Subsequently, we had passed the following order. Subsequently, on 17th, we had passed the following order. Today, we are informed that the petitioner has already undergone medical surgery.
Yes,
and requires 2 weeks' time to recover. Accordingly, we dispose of the present petition in the following terms. Petitioner shall surrender surrender within a period of 2 weeks from today. On or before date 2 weeks के बाद 2 weeks का जो है on or before कर दीजिएगा. Should he require further medical assistance, the respondent state
2nd June Monday
shall ensure the same in accord as per the jail manuals.
Small indulgence. That's the last occasion I directed that he be present before the police station and
that will continue. Needless to add, direction issued by this court as extracted supra shall continue to be.
My only request is 2 weeks, because my doctor asked for 3 weeks, so that there is.
It's almost 3 weeks. 2nd June is almost 2.5 weeks.
Grateful, my lords.
Item 64.
64 Passover.
Yeah, please, my lord, I'm here. My lord, I'm here. My lord, prayer is for grant of anticipatory bail.
No, not in this case.
My lord, I'm not named. My lord, only. My lord, I only take. My lord, only 10 seconds. My lord, I only take 10 seconds. My lord, I'm not named in FIR. Not secret.
When it is an organ. Anyhow, you don't want to say.
My lord, my lord, only 10 seconds. I'll bother your lordship.
Thank you.
Lord, in 65, the bail has been cancelled after 4 years.
Heroin.
Bail was granted on what purpose? For what purpose? FSL report not filed. Sorry. Grossly illegal.
There is no heroin. The FSL report.
Yeah, let us see the FSL report is negative. That is.
My lord, 65. Inadvertently, I missed it, my lord. I'm carrying it, my lord. Original report.
एक मिनट देखते हैं.
The page 2 of the episode.
What does it conclude?
My lord, it says, paragraph 12, my lord, result of the examination. Heroin has not been detected in the exhibit so and so. However, morphine
codeine, that is one and the same thing. Thank you.
My lord,
Thank you.
Cancelled, my lord.
Yes.
Followed.
All right, thank you.
Where do you come from?
Lord, I'm from Calcutta, my lord.
Kolkata.
You enjoyed your
you come
liberty for 4 years.
You as a council come from where?
Calcutta.
Yes. Calcutta proper or rural area?
No, proper.
Huh? I only request you as a young council, I'm telling you, go and see what is happening in the streets. Please. See, we now have a duty to decide which brief to take and which to refuse. The bar must take up that onus now.
Okay, incarcerated for 2 years almost. After that,
yes. You have a right to seek bail before the High Court.
Next case.
Again, regular bill, we can always.
Allow some time.
Next case.
Thank you.
Item 66.
May I please please. Here, Manoj, for a 54-year-old widow. I was
Charge sheet filed.
Granted bail. Manoj, something peculiar in this matter, which is why I have to place it. I was granted bail.
Who are you?
I am Manoj, a 54-year-old widow.
Ah.
Granted bail by an order of the High Court. Granted bail by the order of the High Court. One of the conditions.
It has been cancelled.
One of the conditions in the bail order was this, that you deposit your passport.
You did not deposit
without
roamed or you
No,
went
I did not. That's exactly.
went abroad.
No, I did not. Please see for that paragraph 24. Please have that. I am A3. Therefore, Manoj, I said something peculiar. I just wanted your lordships to have that.
So you didn't go abroad.
I did not go. No violation at all. So this is see 24 at page 20. Please have that. Categorically, the High Court records A2 has gone abroad. A1 took permission and then
You are
A3.
A3.
I am A3 number 1. Widow Manoj, I am dependent completely. I've set that in my list of dates and my
No, just you did not go abroad.
No, it's recorded there.
Who are you?
Private respondent, R2.
R2 accepts notice.
This will have to be state Manoj because I've been directed to.
Not this respondent, Manoj.
No, is he outside or is she inside?
She was inside.
Today, what is it?
She's in.
No, I'm not arrested.
No, she's not arrested.
That's what you are
there. She's out.
Interim order, no, as correct. Operation of the impugned order for the instant petition is
very state.
Notice standing counsel over usual offer.
Worships of granted state.
For the petitioner.
That's very good.
Item 67. Your Lordship, this is a matter where possession of
1 minute, 1 minute, ma'am.
Yes.
Just from one.
Your Lordship, this is a matter where the possession.
Just 1 minute.
Lordships, in this matter, the possession of my suit property has been given to the respondent number 1.
No, because the suit for special performance has been, agreement has not been asked to be specifically performed.
Lordship, I bow down to that, but the point
Therefore,
is.
the position had to be.
Lordship, it is my.
It is a counterclaim. It is a counterclaim which was allowed.
Lordship, but my only difficulty is that I have enjoyed possession
You do
of
one thing.
for decades.
What's your good name?
Shefali, Lordship.
We encourage juniors, so please argue to the extent you can. Please argue. But we have told you.
Lordship,
How do you explain this?
One indulgence to.
Yes.
I'll explain this, Lordship, because there was.
What indulgence do you mean?
To just explain at least.
Most certainly, there is no rush. When it comes to junior councils, there is no rush. Please tell us.
Lordship, it is my case that there was an agreement to sell that was entered into in 1983. I have paid the entire sale consideration, and that point has been accepted by the Honorable High Court also. After that, Lordship, I have enjoyed possession of the property for decades on end. Now, though it may not be documented, but it is my case that for the last 20 odd years, I have constantly been following up for execution of the sale deed. Time was not of the essence in this contract. Now, when I realized the sale deed was not getting executed, I served a legal notice on them and I filed my suit accordingly. My suit may be barred by specific performance, Lordship, but the larger picture is that I am losing my right to the entire property, which has been in my possession and rightful ownership for decades. So only on that ground, I'm asking for notice to be issued, Lordship. I understand the property execution has already been carried out on 9th of May. The property was attached. That was the urgency before, because of which I came before this honorable court today.
The possession has already been taken.
It's been taken away, Lordship. That is my difficulty, Lordship.
What else? How can we help you now?
Lordship, we just, at least I understand Lordships are not inclined to grant a stay, just a notice.
We are not inclined to notice.
Para 11 of the impute judgment.
Yes, Lordship.
Nothing in writing was done by the plaintiff for a period of 20 years.
Yes, Lordship. I bow down to that, Lordship. The first document.
It's a finding of fact. You can't just go against that finding. Thank you.
But Lordship, the point.
Thank you. You are goodwill. What's your good name?
Shefali.
Despite persuasive submissions made, submissions made by we are unable to persuade ourselves. Thank you.
Item 68.
With 68, your lordships have granted you when not connected, But that's my sir. I have a better case than him, and I am requesting for bail. He's been inside for 6 years. If lordships give me 2 minutes, I'll make out the case.
What we'll do is we'll hear both of them.
Yes.
That's it. And your narco test, that's the only thing.
No, there's even on the recovery.
Yeah. Anyhow,
without notice, we can't.
But put your lordships.
Notice they issue no.
On the bail also, my lords, put your lordships consider taking this next week for the aspect of bail.
Why not at 2 o'clock?
Sorry.
Why not at 2 o'clock?
I'll be here, but
no, why not at 2 o'clock?
So
what is the date of the judgment?
That's the date of the judgment is 6th February.
So
these are poor people. The entire record was thinking.
Next case.
Some date in July, if you are very
Some date will be given now, you know that. 69.
In this matter, we have, in accordance with your lordship's order of 21st of April, deposited 20 lakhs subject to the outcome of the.
You have deposited.
Deposited, my lords. We have also shared a reconciliation statement with them showing already made payments, my lords.
Yes, have they deposited the amount?
My lord.
They must have deposited with the court only, my lord.
That's even deposited with the registrar of the
With the
That's the direction. It's deposited subject to outcome.
Okay.
And my lord, we have also shared a reconciliation statement with DDPDC as per your.
What's your good name, ma'am?
Sanjana Sani.
You are appearing for the private respondent, no?
Yes.
We'll examine no difficulty. Now today we will direct that amount to be released to the.
My lord,
1 minute. Subject to the Tikigana.
My lords, may I be given a moment before that?
Certainly.
My lords, payments for all months have been made through banking transactions in terms of your lordship's calculation in the order of which contempt has been.
Very good. No problem.
In their contempt, there is no calculation, there is no allegation.
We'll hear it, don't worry.
My lords, may I only say, let that remain in the registry. We have already.
They are the government.
In fact,
they are public sector.
There is recoverable amount. They have not responded.
They are public sector. The amount deposited by the petition shall be released in favor of the instant petition. Amount deposited by the private
20 lakhs. Their claim itself is of 11 lakhs.
Shall be released in favor of the instant petitioner. This approach shall be subject to the outcome of the present petition. Number one. Number two. Now, who is appealing for the SHA? Now, we are adjourning it today, but we'll tell you that poor lady, the SHO, we will suspend the SHO. We are telling you, because the SHO, what he has done is, he has suspended that poor constable, lady constable. I think that order is uncalled for. You will not do anything, we will not pass any on, we are cautioning you. You may take whatever remedial measures you wish. The duty, this order was to the SHO. At all, anyone has committed a mistake, it is the SHO, not that lady constable. Please, we are leaving it at that today and we will adjourn it. Take whatever.
With great respect, only one thing though, only one.
Yes.
The case of the SHO, that the things was not put into the knowledge.
And this court says that the SHO.
That means the SHO.
No one is the SHO.
Go down.
Today only we can suspend him, have him suspended.
He has to put his house in order.
We are not doing it. Please.
You ask him to act as is falling from my lords.
Okay.
The suspension which you
immediately
directed against
the poor lady constable has been suspended.
You taken out your wrath on regard following the order of this court on the subordinate. That's what happens always.
Uncalled for. We'll keep it next week. Take whatever measures you list on. Thank you, ma'am.
Please. In the meanwhile, can they be asked to place a calculation on record?
You write to them. You write to them.
We've already written.
Right. Next week, we are keeping only for the remedial measures to be taken by the SHO. Rest we will keep it after the petition.
Yeah. Can the personal appearance of Farman in that case be exempt?
At this point in time, the personal appearance of respondent number 1 is exempted. Private respondent Monday to me.
Yeah. Pass over 4.
Lordship, recall that on the last occasion, it was only one issue which was, we had both filed a 2-page note.
Mr. Raju, sorry, Mr. ASG, we'll have it some other day. You want it this side of the occasion or after the occasion?
I would because I think my management will offer. But I leave it to my lords, but see.
It will be either on Tuesday or Friday.
We need it.
This Friday. Friday last working day.
I leave it to my lord.
Tuesday.
Pass over 10.
Lord, in true sense, it's not a case under Section 302. Deep law, there was a land dispute, both sides received injuries, case and counter case.
That will be decided at the trial, Mr. Mishra. This can't be decided at the stage of bail. Based on it, what is the allegation against you? Let us see.
Lord, there are 4 or 5 accused. Lord, our side had also received injury of the same nature. That suddenly, because one lathi blow became fatal, even by somebody.
Lathi is a dangerous weapon. What this court has held time and again.
You are behind bars since 2004?
No, my lord.
Huh?
No, my lord. I am in jail for 1 year, 10 months.
1 year, 10 months. No, FIR is of
2004. Yes, of 2004. Admittedly, the FIR is because of some land dispute and case and counter case both. But the jury.
What do you say counter?
My lords,
what do you say in your counter?
There are totally 8 convicts in the matter or 8 appellants. And out of 8, 2 of them were released on bail by the Honorable High Court.
Distinguishing their role.
Well, there is no distinguished role. They have no.
They are on ground of age.
74 and 69, yes.
The Honorable High Court has taken some holistic approach while granting them bail. And they took the case of these 6 accused not to be relevant to be considered as That's the postmortem report as well.
Where is the postmortem report? Can you point out the
It's the statement of
There is a postmortem report there.
Where is the statement of the doctor? Point out that part of the judgment.
No, sir, page 59.
59.
Page 59 of their selfie. It's the cross-examination of PW5 who
the doctor.
Yeah, yes, so took the postmortem. As it says that according to the cross-examination of PW5, there were stitches on Ifrit 2 and Ifrit 4, which clearly shows that the deceased was treated in a hospital for death. He wrote the name of the deceased on the basis of the form given by the police. He had died about a day before the postmortem.
What is the nature of injuries?
Page 57. Why don't you place on record the testimony in the postmortem report?
As of now, my lords, we do not have.
Mr. Mishra, you do that. Place on record.
What is the condition of the statement of the eyewitness and the statement, the medical evidence?
The
2 things.
The testimonies of the eyewitnesses and that of the doctor, along with the medical report, be placed on record. List on Wednesday. Will you be in 2 days' time?
No, vacation.
तो vacation के बाद जाएगा.
Wednesday we can do lot.
Friday तक कर दीजिएगा. मतलब 2 दिन में कर दीजिएगा. Wednesday, Thursday, Friday को लग जाएगा.
It may be listed on Wednesday.
Wednesday.
Passover 21. I'm seeking accommodation for today. My lord,
sorry.
Sir, he is in personal difficulty for today. My lord, only for today itself.
Ma'am, while we were discussing the matter, you said pass it over.
My lord, may kindly have it on Tuesday. And it's a humble request, madam.
Tuesday.
Yeah. On her request list on Tuesday.
Obliged. Passover 21.
Why don't you yourself argue on the next day?
I was not instructed.
On the next day, please argue.
And will be doing. Passover 26.
Because the employee has been working all throughout, though in 2011-12 it is alleged, and a compulsory retirement in 2019. No action taken against any of the.
He has been convicted for 409.
Yes, against which an appeal revision has been filed in the High Court, which is pending, and the judgment is stayed. Now, during this entire period from 2011 till compulsory retirement, after compulsory retirement, continued on work,
Sorry.
This is only request is, while
you cannot.
Because he's the only accused found, what they have done is
for early disposal.
What have they done? The secretaries, I was only an appeal level clerk, and no action has been taken against any of the secretaries.
Should feel happy. Only despite conviction in 409, you have only been compulsory retired. Otherwise, the harsher punishment should have.
The appeal, the appeal, if it can be directed that it may be heard. And
can never be directed. Sorry.
Please, oblige.
Passport 27.
Yes. Yes, please.
The Lordships would desire this.
Who had drafted this? You had drafted this.
My colleague, it's an error on our part. It's an error on our part. And which is why even on day 1 I had requested that without it.
Why do you even venture into accepting such briefs? This man, does he deserve any kind of audience? Rather, he deserves heavy cost, exemplary. He is leveling all kinds of allegations against officers. For his whims and fancies.
And you drafted. I'm surprised. I thought some newcomer had drafted this.
my colleague is in error, but we're very remorseful for it.
No, I know him.
Yes,
In the bar.
of course.
But absolutely shocking. But not on the council.
Which is why on day one also I request, without adverting to the merits itself, I request.
We have gone through the petition, the order is also there, very clear.
Absolutely.
Such litigants have to be deterred with iron hands. Because they can't get away with these things. Having written everything in the petition and drafting, leveling allegations, all sort of allegations.
Yes,
right,
sir.
left, and
Yes, sir.
center.
I understand.
Wants to-
Morning only we told someone that now it's about time that the greater responsibility on the bar, members of the bar is to decide which brief not to take. With the e-filing now, what has happened is after COVID, pan India, everyone is coming to this Supreme Court. Bound to be very welcome. But then what to accept, what not to accept is in our hands.
Yes, sir.
And what to write and what not to write is also.
Which is why even on day one, your lordship, I did not.
Anyhow,
advert on merit.
you tell us what cause should be.
Your lordships,
Some cause.
the person is not of means, but I leave it to your lordship.
No, nothing. This doesn't deserve anything, any sympathy.
Dismiss, dismiss this petition. We are not inclined to, considering the amendments made in the petition, colon, the nature of the order passed by the court below, which is impugnable herein, and the submissions made across the bar, we are not inclined to interfere with the order. As such, we dismiss the petition with cost quantified at rupees 25,000 to be deposited.
Deposit with the legal services.
Legal services.
Legal services. Supreme Court legals.
Great.
Be careful, sir.
We are extremely remorseful, your lordship. Apologize.
Pass over 58.
Well, I custody since December 2023, my lord. Charges have not been claimed.
You were granted interim bail for 4 months.
Yes, sir.
After that, if that period has expired, you have to go to the High Court.
So the thing is that I have paid for
How can you be in custody when you have been released by the High Court? Right now, are you in custody or not?
I don't
Then you have to go to the High Court, seek extension. Why are here
I filed regular bail in the High Court.
So all right, go, argue. Who stops you?
Instead of granting me regular bail, the High Court has passed the interim.
Then why did you avail that period of interim bail? You should have refused. The order is of 15 January.
Yes,
you should have challenged it then and there. It's nothing. You should approach the High Court.
Drawn with the permission to approach the High Court, seeking regular bail.
Pass over 60.
May it please, my lords. My lords, the order of the High Court, my lords would recall, was uploaded yesterday. Would my lords have me file it on record by way of?
Well, we have the order now.
Yeah, my lords, that is the case. My lords, the High Court.
Yes.
At paragraph 6, misdirected itself to the question. Actually, this witness is crucial for my defense, which is why I filed a 311. The trial court, being conscious that the witness is relevant, allowed my application of 311. My defense written, my evidence was also allowed, but because the police did not execute the warrant, I'm being faulted. I served the witness on 5 occasions. He did not appear. My only humble request is, my lords, is if the trial court will be directed to issue a non-bailable warrant to the witness and let him come and give us evidence.
We don't fix it, sir. I'll get the direction. Let's go. Now the first opportunity that doesn't matter, the high trial court found that the witness was relevant, no dispute. Was it not your lords? Maybe. So is it in his hands? Is it in the hands of the accused to get the witness to court? The accused goes and serves the summons. If he doesn't come, it's a non-compliance of the trial court's order. If he fails to execute the bailable warrant on the ground that he doesn't want to really disturb the relationship between the bank, and then blame it on the trial court. The bailable warrant will go through the court process. He can't. He has to take it custody. He has to follow up the police and once the witness has been found to be relevant, he has to be examined. Otherwise, your complaint will fail on the ground that the defense is prejudiced. The Lordship is inclined to give him an opportunity, and I have no problem with my lords. Let it be the last opportunity. That's then the trial should be completed within a timeline that your Lordship says. Where's the trial court's order?
Because the High Court has dismissed the petition, na?
Yes, my lord. No, I trial court later close the evidence because the witness did not turn. Where are the orders? Read.
My lords, the trial court orders at page 79.
Firstly, wherein the trial court held that the witness should be summoned. Where's that order?
Lords,
that order you have not placed?
No, we have placed all the orders on record.
I have a
Page 79 is the evidence which was the defense.
My lord, it's at page 69, where my section 311 was allowed.
Yes, let's see that.
Page 69.
To issue witness summon to so and so.
We issue witness summon to the authorized officer and any other person and the RBL bank. I had issued summons on 5 occasions to the police. And
69 order 69 the proper formats mein order diye.
Complainant is present. We issue summons to the. So then what happened?
My lords, then after that I had issued summons on 5 occasions to the police. I had even contacted the police, and because the warrant is supposed to be filed to the police. After that, at page 79, the High Court dismisses the 311 saying that
the trial court
closes
the evidence saying that the witness is not turned up.
He is not turned up. He is not reported.
Just one minute. It is seen that on 27th of it is seen that recordedly on 27th of September 2024, the trial court had passed the following order.
19th September. 19th September.
19th September had passed the following order. This quick extract will be page 70. Yeah. It is not in dispute.
After it was reopened and again closed.
Just one. It is not in dispute that the instant petitioner had taken all steps for summoning the witness. Which fact is evident?
In my application under 311 at page 85.
75 wala order. The witness did not turn up, so bill for
which fact is evident from the order dated 30th of November 2024, for the court had issued variable warrants against the witness. The said order is extracted as under page 75, dash to dash. It is not in dispute that no, it is not the case of any one of the or the respondent herein that the instant petitioner failed to take steps in that regard.
Process application page 76 के process annexure PA 18 meters.
In fact, the process application in compliance of the said order was filed, which is on page 76 of the instant petition.
Court fees.
The steps complete in all respect were taken by the petitioner, instant petition, for recurring attendance of the witness. It appears that on 3rd of January 2025, the trial court observed though erroneously, that the witnesses had, that the instant petitioner had not taken any steps for executing the warrants against the, in relation to the witness. And as such, on 3rd of January 2025, closed the evidence, closed the defense evidence. Full stop. Resultantly, the instant petitioner preferred a petition before the High Court, assailing the order dated 3rd of January 2025, which stands rejected in terms of the impugned order. So, having heard learned counsel for the parties, has also considered the material placed on record. We have the considered view that the High Court ought to have interfered, ought to have exercised jurisdiction by quashing and setting aside the order dated 3rd of January 2025, whereby the defense evidence was closed. For the instant petitioner, had taken all necessary steps in compliance of the orders passed by the trial court, ensuring attendance of the witness. The such, in fact, the High Court proceeded to examine the minutes of the matter,
summoning order. Order summoning the
minutes of the matter in summoning the witness, which in our consideration was not required to be gone into at all. So all that was required to be considered was as to whether the petitioner had taken steps in compliance of the orders passed by the trial court. Not. We find that the petitioner has had taken steps and is in that direction, and as such, we quash and set aside the impugned order dated so and so, the High Court wala, as also that of the trial order dated 3rd of January 2025 passed by the trial court 879. We direct the trial court to take steps or take steps for ensuring the presence of the witness in accordance with law, be it including to the coercive process. The party shall appear before the trial court on dash को date दे दीजिएगा. The petitioner shall take all steps, if so required in Dutch.
If you apply,
the evidence of the witness shall be, the trial court shall try to conclude the trial within next.
Court shall endeavor to conclude the trial within the next 3 months.
My lords, and final arguments may be heard afresh because I was
whatever. Okay. What we'll do now is that unless there is some order which needs to be extended, your matter is over.
Right.
In some case where orders needs to be extended, is there any case where interim order needs to be extended? Otherwise, what we'll do is that we'll space out the matters, leftover matters, because the bench would not be sitting now for the day. So we'll space out these matters and the dates would be clear. Could date दे दीजिएगा. जो bail है वो 7 bail कोई नहीं.
36, the interim order was today, my lord.
No, we will extend all interim orders to be extended.
If item 36, let the respondents be permitted to file counter affidavit.
1 minute. I am ऐसा करूँगा. जिसमें readings complete नहीं है, उनमें time दे दीजिएगा 4 weeks, 2 weeks और date दे दीजिएगा July, August में. और जिसमें interim order extend होना उसको extend. ठीक है? एक piece है जिसमें आप
Lordship's item 20.
One minute. I'm coming to that. We are aware. Yes. एक केस है item 40 और एक केस है which is our item
28.
28. इसको आप अगले हफ्ते रखें.
Your Lordships, I can, I'm tendering this report.
Whichever इसको आप Monday को कर दीजिएगा या Friday, Monday, Tuesday या Friday. देख लीजिएगा कितने केस हैं.
1840.
हाँ. Tuesday को कर लीजिए. Tuesday को.
I joined the academy.
आपने सुना नहीं हमने क्या बोला? We speak in Hindi now, so that anyone can. Or wherever date interim order is to be extended, will be extended. Wherever pleadings are to be completed, we will give you time, 4 weeks, 2 weeks, all matters, dates will be given.
Thank you. In addition, can I request only one thing, item 32, just I will request it may be listed for NM, because it requires presentation.
Correct.
Great.